she gets convicted, I didn't have a choice but to send her to prison. She has no prior record. Why would you drag your daughter into that who has your grandchild at home? What, 4 months old, 5 months old? Why would you do that? But to talk your own daughter into doing something like this is just absolutely disgraceful. 25 CR 42362, the state of Ohio versus Kenneth Carney. Mr. Carney is before the court. Mr. Carney, have you retained new counsel?
I didn't get a chance to because I'm gonna wait till after the holidays. I think he had a caseload over. He had too many cases. So the ones that I never try to call, because I got back to Lucasville December 15th. By the time I got to use the phone and call lawyers, they told me I'll call after the holidays.
Mr. Carney, this is unacceptable. I'm not going to continue to drag this case out. This case is approaching a year old already.
You're saying that's unapproachable? What's unapproachable about it? I can't make a lawyer come to work. They was busy. It was the holidays.
Well, I'm going to appoint you new counsel today.
And then you give me a lawyer last time. He ain't even do nothing. I asked, he ain't come and see me. Still ain't got no discovery or nothing. James Moss ain't giving no discovery. I don't even know what's going on. Never came to see me or nothing. So how's it my fault?
Well, I just said I was going to appoint you counsel.
I know,
I'm going to set this for trial here in the next month or so. This case, like I said, is almost a year old. We've had.
Yeah, but
I'm not, sir.
Sir, what?
This is not time to argue with me. I'm telling you what I'm going to do. I'm going to appoint new counsel. Now, if in the meantime, between now and 2 weeks from now, that you hire a new attorney, that's fine. But I need to keep this case moving. This case is almost a year old, and I've had it set for trial twice already.
Yeah.
This will be the third trial setting. I'm not going to continue to play this game. So here's where we are.
No
Mr. Laux is going to hand you a form. It's an affidavit of indigency saying you can't afford to hire an attorney. If you come up with the funds and you hire an attorney in the meantime, that's fine. That's great.
Yeah.
But in the meantime, I'm going to appoint someone to represent you. Are you still at Lucasville?
Yeah.
Okay. All right, so I'm going to go ahead and accept this today, and then again, like I said, if you end up retaining someone, we're after the holidays now. If you end up retaining someone, they can reach out to me and substitute in as counsel of record. That's not a. As to the additional finding to count one, we, the jury, find the amount of methamphetamine involved in the offense was equal to or in excess of 5 times the bulk amount, but less than the 50 times bulk amount. This additional finding is also signed by all 12 members of the jury. As to count two, we, the jury, being duly impaneled, sworn, or affirmed, find the defendant, Kenneth Carney, guilty of illegal conveyance of drugs of abuse under the grounds of a specified government facility. As he stands charged in the indictment, this verdict form is also signed by all 12 members of the jury. Does the state want the jury polled?
No, Your Honor, thank you.
Does the defense want the jury polled?
No, Your Honor.
Before I pronounce sentence, anything from the state?
Your Honor, the court heard the testimony in this case. The court's aware of the facts. The defendant has an extensive history of drug trafficking dating back to at least 2006. This was 51 grams of methamphetamine that he got his daughter with no criminal history to bring in to the Warren Correctional Institution for him. And the court heard his testimony. So we would ask you to consider all of that and impose a sentence of at least 6 years.
Mr. Brenner, anything on behalf of the defendant?
Thank you, Your Honor. I've gotten to know Mr. Carney pretty well over the last couple months I've been on this case. I think he's a polite man. I think he's an affable man. I think that he's in a situation where I know this court's well aware of the circumstances surrounding, the Department of Rehabilitation and Corrections. Obviously, we think he made some bad choices here, right? I think that he sought to, alleviate his circumstances as it was. But I do know that he has, I know the court's aware, he's been transferred to Lucasville. It's a much higher security level. I know that is not enjoyable for him. I think he's already faced some consequences. I would ask this court to issue an appropriate sentence on the lower end, as I think it's notable. Obviously, none of the contraband was ever actually possessed by Mr. Carney.
Mr. Carney, is there anything you'd like to say before I sentence you?
I just apologize. There's nothing I can say. I apologize to the court. I have nothing to do with it. I still remain innocent, but
I'm sorry, I can't hear you.
I still remain innocent to where I didn't do it, but There's nothing I can do about it. I can just apologize to the court. That's all.
You know, the court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. There are two offenses here. The court does find that they are offenses of dissimilar import and do not merge for the purposes of sentencing. Anything on that?
No, the state would agree.
Your Honor, I would ask for them to merge, but I do believe that under Ohio law that they would not automatically merge.
All right, on count one, then, the court will order you to serve a minimum term well, before I get to that, Mr. Carney, first off, shame on you. Just absolutely shame on you for dragging your young daughter, who you profess to love, into this. You know, I quite frankly agree with the jury's verdict. I don't often do this. This is probably the second time in 10 years that I've actually sentenced a defendant in front of a jury, and I'm doing it for a reason. Because just absolutely shame on you for putting your daughter through this and having her face an indictment with mandatory prison. Luckily for you, I think that the state, and I think we're going to do it on Thursday, her trial was set for Thursday, as you probably know. If she gets convicted, I didn't have a choice but to send her to prison. She has no prior record. Why would you drag your daughter into that, who has your grandchild at home? What, 4 months old, 5 months old? Why would you do that? And that's a rhetorical question, Mr. Carney, because quite frankly, I'm not looking for a response at this, but I'm just scolding you because I think it's shameful for a parent to drag, and we see these cases all the time where people, they talk these young women, but to talk your own daughter into doing something like this is just absolutely disgraceful, in my opinion. Your record dates back to 2001, your criminal record. So you have a criminal history of over 25 years. This is your third conviction for aggravated trafficking. 3. You're not learning anything. So the court is going to order you to serve a minimum prison sentence of 5 years, a maximum prison sentence of 7.5 years. That has to do with Reagan Tokes, as you probably are aware. And on count 2, the court's going to order you to serve 36 months. That to be served concurrent with count 1, but consecutive sentence to your current sentence. So I'm adding on 5 to 7.5 years to your current sentence. The court does find that a consecutive sentence is necessary to punish you and to protect the public from you. It is not disproportionate to the conduct or the danger that you pose to society, and this offense was committed while you were already incarcerated in the Department of Corrections. You have 0 days jail time credit. You are subject to a mandatory period of post-release control on this, as you probably already are on your other one, which means that when you are released, the Adult Parole Authority will supervise you for up to 3 years, but not less than 18 months. You do have a right to appeal the jury's verdict and this court's sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. You can't afford to pay for the transcript or anything necessary for your appeal. That can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Nicholson.
Nothing further, thank you, Your Honor.
Mr. Brunner.
Not at this time.
All right, that's all. Thank you. All right, ladies and gentlemen, at this time, we are obviously finished, and I oftentimes don't ever do that. I've done it one other time that I can think of. I will explain that to you in the back.
How long it take for the appeal to come in?
Well, I mean, so I'm gonna file it. It'll, like we talked about, it'll probably take a couple weeks to a month with the transcript ready. And then from there, your appellate counsel will have, 4 to 6 weeks to file that brief. Okay? Oh, that's right. I'll file that.
Are you able to take us off the record?
361, the State of Ohio versus Kalia Carney. Ms. Carney is before the court with her counsel, Mr. Staten. Ms. Nicholson on behalf of the State of Ohio. Ms. Nicholson.
Your Honor, Danny and the defendant will be entering a guilty plea to the amended counts 1 and 2, which have both been reduced to felonies of the 3rd degree, aggravated trafficking and aggravated possession, as well as count 3, illegal conveyance. Count 4 has been dismissed. There is no agreement on sentencing. However, the state has indicated to Mr. Staten that it intends to defer to the court.
Staten, is that accurate?
It is, Your Honor.
All right, Ms. Carney, they're telling me you're going to change your plea to guilty to 3 counts, 2 amended counts, and 1 additional count from the indictment before we get to your change of plea. I am required to go over some things with you, okay?
Okay.
How old are you?
I'm 22.
How far did you go in school?
I went into high school.
So you can read and write?
Yes.
Did you graduate?
Yes.
Okay.
I got my high school diploma.
Okay. Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you in this matter?
No.
Has anyone threatened you in any way to get you to plead guilty
No.
against your will?
No.
Are you satisfied with the representation you've received from Mr. Staten?
Yes.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes.
Did you read this, go over it with your attorney before you signed it?
Yes.
And you feel comfortable that you understand what it says?
Yes.
All right. This document says running a plea of guilty to one count of aggravated trafficking in drugs as a felony of the third degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. $5,000 of that is a mandatory fine. The second count is one of aggravated possession of drugs, a felony of the third degree. That also carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. And again, $5,000 of that is also a mandatory fine. And the third count is one of illegal conveyance of drugs into the grounds of a specified government facility, a felony of the third degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. None of these carry mandatory prison sentences. Do you understand the maximum penalties and maximum and mandatory penalties?
Yes, Your Honor.
All right. Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison, when you are released, the Adult Parole Authority may decide to supervise you for up to 2 years.
Yes.
If you violate that supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir. Yes, Your Honor.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
Ms. Nicholson.
If this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about July 28th, 2024, at Warren Correctional Institution in Turtle Creek Township, Warren County, Ohio, the defendant transported in a concealed a flaming hot Cheetos bag containing over a bulk amount of methamphetamine. He entered the institution and concealed that in a trash can for retrieval. She did that in conjunction with her father and an associate of her father.
Mr. Staten, anything on those facts?
Nothing, Your Honor, thank you.
Ms. Carney, did you hear the statement that was read?
Yes.
Do you admit and acknowledge that what she said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty,
Yes.
the rights we went over.
Yes.
What is your plea?
Guilty.
All right, the court's going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights, and the court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Now, Ms. Carney, I'm going to order a pre-sentence investigation. We'll come back in a few weeks, and we'll do sentencing at that time. It'll probably be 6 to 8 weeks before we do sentencing, but you need to go back down to court services this morning?
Yeah. No, not yet.
Okay, you need to test this morning?
Yeah, she told me to come right after court so I could be able to sign the papers and everything.
All right, yeah, and that's, you need to set up, or you need to schedule your interview for the pre-sentence investigation.
Okay.
All right, State of Ohio versus Kalia Carney. Ms. Carney is before the court with her counsel, Mr. Staten, Ms. Nicholson, on behalf of the State of Ohio. We are here for sentencing. There was a pre-sentence investigation prepared. Anything on behalf of the state?
Your Honor, note for the record that counts 1 and 2 would merge for purposes of sentencing, and the state will proceed on count 1. Beyond that, we have nothing.
All right. Anything from probation?
Nothing further, Your Honor.
Mr. Staten?
Thank you, Your Honor. Obviously, the court's well aware of the circumstances in this case, having sat through the trial of the co-defendant. We would just like to point out that my client has no record prior or since this incident. She was pressured clearly by her co-defendant into doing this and just wasn't strong enough at that point to deny him. And that is how this happened. She has been cooperative. She testified at trial, which was very difficult for her. She has a lot of family support. Her mother's here with her today. Her other family members have come with her in the past. She has strong family support in the community. She has 2 infants for whom she cares and has the primary responsibility to care for. She is employed. She just got hired and just started working full-time. I think it's full-time.
Yeah.
This last week. We would ask the court to strongly consider not removing her from her responsibilities and her children, allowing her an opportunity on probation to address the issue she does have with marijuana use, which is, she realizes is something she can't do, and she's under the supervision of the court.
Thank you. Ms. Carney, is there anything you'd like to say?
Yeah, say that I was naive in this situation, and I'm sad that we couldn't meet a different way, but I did learn from my lesson, and I learned from it, and I just want to do better and get myself back together.
Who's with you in court today?
My mom.
Mom, anything you want to add to any of this?
Yes, if I may, please.
Yes, please.
Marilyn Hall. Their dad has been in jail most of their life. I think he kind of used my daughter. He got the closest with her out of all 4 of my children. And I went through abuse with him, all types of things, so we've all been through it. I tried to keep her away, but just trying to have that relationship she never had. The other 3 kids didn't get that close with him. And I'm so sad about this whole situation because she's not like that. She worked with me being a DSP. She lost her job, everything. It's just been a lot.
All right. Well, thank you. Ms. Carney, is there anything you'd like to say?
Yeah. I'm just tired. But I'm ready to take my accountability and learn from it and just push through and make everything better and at least try to give me a career again.
Okay. All right, the court's considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court has considered the counts 1 and 2 and finds them to be similar offenses of similar import, and they will merge together for purposes of sentencing. The state electing to proceed on count 1, is that correct?
That's correct.
All right. The court does find, based upon all of the information, Ms. Carney, and I obviously sat through the jury trial of your father, where you were a witness on behalf of the state. The court is going to find that you are amenable to community control. So I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You are ordered to refrain from the use of any drugs, alcohol, or marijuana. Do you understand?
Yes, sir.
I know that marijuana is something that's part of your life right now, but you have been diagnosed with a substance use disorder involving marijuana,
Yes.
so I'm not going to allow you to continue with that. Do you
Yes, Your
understand me?
Yes, Your Honor.
All right. I am going to order you into the treatment for that substance use disorder. You're ordered to complete the thinking for a change course. You're ordered to get and maintain full-time verifiable employment, which apparently you already have, so that's good. You are trespassed from all Department of Corrections properties, so you're not permitted on any property of any prison or state-run facilities. Do you understand that?
Yes, Your Honor.
And you're to have no contact with Kenneth Carney. I know he's your father, but the contact you've had with him did not end well for you, so I'm going to forbid you to have any contact. You know you'll be on the no contact list at the prisons. You can't go to see him, and all of the phone calls are recorded. So if you try to have contact with him, they're going to find out. Okay, so don't. Right now, you just can't. He dragged you into a big mess, and this was very unfortunate, and I feel very bad for you. But I don't know how else to say it, but a good father would not have involved his daughter without a criminal record into this type of criminal enterprise. I don't care what benefit there was to him. That's not a very good idea in any case. It shocks me, to be honest with you. And then for him to force you to testify against him actually makes it even worse, in my opinion. But I am also going to find you indigent for the purpose of any fines, costs, or other financial sanctions. Do you have any questions for me?
No.
All right, now I know you're still continuing to test positive for the marijuana. I want that to stop, so they're gonna start checking your levels and making sure that those levels are going down to 0. Do you understand?
Yes, Your Honor.
Thank you.
Best of luck to you.
Thank you so much.
Thank you so much.